All right, Lehman Brothers, General Motors, it's been a busy year for our next guest. He's led the legal teams assigned to get these companies in and out of bankruptcy. Now this morning, CIT Group says it is, quote, in active discussions with regulators about a rescue. Let's bring in Harvey Miller, partner at Weil, Gotshal, and Manges. And Harvey, thanks for joining us.
My pleasure.
Let's talk about, first of all, I thought it was interesting when Steve Ratner stepped down yesterday, and it was sort of implied that he did it because he's done with the bankruptcies of GM and Chrysler. But it doesn't seem like the lawyers are going to go home. These bankruptcies are really over and done with. Asset sales are finished. Isn't there still a lot of work to do?
Not for the auto task force. Their mission was to set up GM and I guess Chrysler as reorganized or restructured entities. That's been completed. And I really believe that by the end of August, the task force will be gone.
Well, gone completely, the task force, but does that mean the bankruptcies will be over? Do they still have a lot of work to do as far as General Motors and Chrysler's reorganizing, asset sales, etc.?
The winding down of the, let me call it old GM and probably old Chrysler, will take a significant period of time. But it will not involve anything like the task force. It'll be an ordinary liquidating bankruptcy.
Let's talk about how that works, because it seems like there was a lot of attention given to these two bankruptcies, not only because of the size of the companies involved, but because of the secured debt holders and how they were treated. How does a bankruptcy actually go? Is it really dividing property among creditors depending on where they are in line to get that, or is it, I mean, what's the drama like? What's the politics involved?
Generally, you're correct. What you do in bankruptcy is you establish what the size of the pie is. That is the value of the assets. Once you establish what the size of the pie is, then you know who's going to participate in the reorganization. And then there's a hierarchy of priorities under the bankruptcy code. If you were doing a traditional Chapter 11, there would be a lot of negotiating as to who shares in what and what compromises various constituencies want to make to have a consensual plan. The GM and Chrysler cases were different because they were asset sales. The objective was to transfer assets which were considered fragile, and before they could deteriorate in value, is get them out of the bankruptcy process, get the maximum value you could get for them, and then leave the bankruptcy case as a liquidating bankruptcy, probably with a waterfall under the priority scheme.
Now, in this case, how do you think, for example, the secured debt holders in the Chrysler situation were treated? Was it legal? Was it unprecedented?
I would say it was unorthodox. But the issue in Chrysler is what was the worth, the value of the collateral security? The proponents of the 363 sale said the value of the collateral was only $2 billion. The pension funds and I guess others originally said, well, we have a claim for over $6 billion. Well, under the bankruptcy code, a secured creditor has a secured claim to the extent of the value of the collateral. The deficiency, which is the excess over that, is just a general unsecured claim. And in all of the contests in Chrysler, the pension funds never questioned the value of the collateral security. So I know there's a lot of to-do about invading secured creditor rights and the government trampling on such rights. I think in the final analysis, that's not true.
And do you think then that that will have really no repercussions on the way bankruptcies are treated, the way bankruptcy cases are decided in the future?
No, because Section 363 of the Bankruptcy Code gives you an alternative to preserve going concern value. That's not going to change. In cases in which you have fragile assets that could decrease substantially in value because, like Lehman, we used the phrase a melting ice cube, or like GM, where you had to depend upon consumers, those kind of cases will continue. Other cases which have different types of assets will go the more traditional route.
And what do you think about the possibility of, or let's say the readiness of people to lend in these positions as secured debt holders?
You know, I've been around a long time in this business, and I've heard financial institutions say, we will never lend another penny to this industry on the basis of some decision in the bankruptcy court or elsewhere. And 3 or 4 months later, they've totally forgotten. There is no institutional memory in this world.
All right, very interesting point there. Let me quickly ask you about CIT. It looks like they're on the brink, obviously. They're far from, and we're not saying that they're filing bankruptcy. Have you heard any concerns about the small or medium-sized businesses that get money from CIT?
Oh, sure. I mean, CIT has been historically a middle-market lender, really a hard asset lender. Under Mr. Peake, they expanded their horizons, took on a greater percentage of risk And now you have a lot of middle market businesses that were depending on CIT for financing. And in today's media reports, you read stories about companies who thought they were going to get an advance and they're not getting it.
Just 5 seconds left. Chances that CIT gets bailed out, your opinion?
I think there's a tension between the FDIC and the Treasury as to what's the right approach.
All right. Hey, Harvey, thanks so much for joining us. Harvey Miller there. We're going to take a quick break here on Bloomberg. We're back in 2 minutes.